We're going to be talking today about the incorporation process and some basic information that you're going to need to know as you start this process of becoming a new business. A lot of people are not familiar with the process of incorporation, and they think that calling themselves a corporation automatically authorizes them to become one. In the state of California, in order to be a corporate entity, whether it be an Inc. that we know of, a corporation, or an LLC, you have to register with the appropriate state agencies. In California, you have a couple of state agencies that regulate business formation and business operation. The primary one is the state of California's Secretary of State that has a business entities department, and they are in charge of enrolling and keeping track of all corporate entities in the state. There's also the Department of Corporations, which is now called the Department of Business Oversight, which also regulates and makes sure that businesses are complying with regards to shared transfers, securities, laws, etc. What does it mean to incorporate in addition to registering with the state? It means that you are going to have to pay a filing fee to the California Secretary of State, which generally runs about $100 to file your articles of incorporation or your articles of organization if you're going to be an LLC. We're going to focus primarily on corporations during this discussion because most operative companies in the state of California, meaning that you are going to have a business, you're going to have employees, you're going to be in operation, should generally consider being a corporation versus an LLC. And if you have questions on that, it's always best to ask an attorney or even a CPA to help guide you on which you should be. But in my experience, most of the corporations that are starting off are going to fall within the corporate sphere, so that's what we're going to be talking about. The next step that you're going to want to do after filing is you want to make sure that you know what your legal obligations are now as a corporation. A corporation is considered a person separate and apart from the owners. It has rights and it has obligations that are independent to that entity. In order to retain the benefits of owning a corporation, like trying to shield yourself from personal liability from any corporate acts or wrongdoings of the corporation, you need to make sure that you treat the corporation as a separate entity and that you respect the corporation as such on an ongoing basis. So it's important to know what obligations you have as an entity and what are the boundaries that you must have between yourself as the owner and the corporation. In a corporation, we also have issuance of stock. A closely held corporation, which is going to be a majority of the startups in our community, means that there are 100 and less shareholders owning that corporation. There may be a couple of you, there may be a team of you. You are probably going to be considered a closely held corporation for that reason. And you also have the opportunity to then make what's called an S election. And the S election is a tax election that you make with the IRS that allows you to avoid double taxation as a corporation. So what it does is it eliminates the double taxation that naturally occurs in corporations when the corporation itself has to file taxes and pay taxes, and then when it makes distributions or dividends to its shareholders, then the shareholders themselves have to pay taxes on those distributions or profits that they receive. In an S corporation, that is eliminated and the taxes flow directly through to the shareholders, and there's only one level of taxation at the shareholder level. So that's an important step to make, and a determination that you should make both with legal counsel and a certified public accountant. However, once you've made that determination, then the next step is to maintain your corporate entity. And one of the first things that you're going to do as a new corporation is you're going to need to have an organizational meeting. That's where you bring together your board of directors. There can be one board of director if you're a really small company, or you could have a couple. You could have as many as you want. Generally, in closely held corporations, the board of directors are also the stockholders, are also the owners of the company. And their board representation is generally going to be equalized based on their pro rata interest in stock. For example, they may get to pick the number of board of directors that you get to pick may be determined by your stockholdership and the voting, etc. So the document that lays out how your corporation is going to work is called the bylaws, and the bylaws is a document that's required in the state of California for every corporation to have. It is not a document that is publicly filed. No one sees it, but you do make representations when you start off as a business that you're going to be bound by the state of California laws over corporations, and that is one requirement. So if you get audited, whether it be by the Secretary of State or the IRS or the Franchise Tax Board, they're going to want to make sure that you have complied with the corporate rules, and they're going to want to ask you where your bylaws are. The bylaws speak as to how many directors you will have in your entity, what the voting process is, what the notice process is, when the meetings will be held, how they will be notified, and other important information regarding your corporation. Once you have those documents and you have your organizational meeting, you can get together with all of your fellow board members, who will probably be your fellow owners, and you can appoint at that point in time who your officers will be. In the state of California, you have to have at least 3 officers. You can have one individual that occupies all 3 seats, but you do have to have at least one president, at least one treasurer, and at least one secretary. And their duties are defined in the corporate code. But generally, there are kind of what we anticipate that they will be. The president is going to be in charge of generally the operations and management of the company. The treasurer is going to be in charge of making sure that the finances are properly documented and accounted for. And the secretary is going to essentially keep track of meeting minutes and make sure that the corporate compliance is done. Any of these tasks can be delegated, but that individual assigned is going to be responsible for that. Those are technically appointed positions, so they can change. Every year you'll have to notify the Secretary of State through what's called a statement of information on who those people are, what their addresses are, so that the Secretary of State knows and the public is aware of who needs to be contacted and who's in charge of the corporate structure. So what are the benefits of incorporation? It depends on what your company wants to accomplish. A lot of people want to incorporate because they want to try to prevent themselves from being personally responsible for the acts of their fellow co-owners, for the acts of employees, for the acts of their corporation itself. So for example, if you create a product, and when you have a product that could present some harm to the public, to the consumer, or anyone who acquires it, whoever created that product could expose themselves to liability if they place a product in the public stream that could create hazards, etc. So when you incorporate, and this is a product of your corporation, and the people who have created it are now acting outside of the reasonable standard of creating a product, then if something goes wrong with that product, then only the corporation would be held liable for any defects in that product. And you as the president would not be personally held liable for any resulting damages. So that's very important for companies who have high risk areas, for a restaurant, for a bar, for someone that's creating a potential health hazard product, etc. It's vital so that you can feel comfortable that you yourself are protected. So that's one of the main reasons why corporations are formed. Another one is expansion. People have and want to grow their business. And in a corporation, it is much easier to grow a business because later on you can add investors, you can give them stock, you can reward employees with stock options. There's a lot more that you can do with a corporation that you aren't able to do as a sole proprietorship or general partnership or any of the other legal entities like an LLC. So that's another reason. Public image is another reason. There's companies who rely very heavily on grants or who may rely heavily on government contracts. And in order for them to be able to be marketable for those types of audiences or consumers, they need to have a formal structure. The consumer, the buyer, the client wants to make sure that they're dealing with a legitimate entity that's here to stay, that has some responsibility and corporate obligations. They may want to see the formation documents, and they may want to see some compliance on the owner's part with corporate structure. So public image is also a reason why people incorporate, to create more of a legitimacy to their business. Additional is taxing. Once you get to a certain size and certain income revenue, there are a lot more ways to be able to use income creatively within a corporation that you are not able to do on your own. You can create retirement accounts for your employees. You can create profit sharing. You can also take advantage of some benefits given to corporations tax-wise. So that is generally sometimes only open to corporate entities. So that would be another reason to incorporate. The general costs, hard costs, that you're looking at in terms of incorporating are going to cost you about $500. And that's going to include the filing of the articles of incorporation, the registration, the book, your corporate minute book, the filing service if you choose to use a filing service, and any additional miscellaneous costs that you're going to have of just getting your company started. If you choose to use an attorney, those fees can range. Our services are generally about $1,200 to $2,000 depending on how much is going to be done at the outset for this corporate entity. We have situations where people start off as an LLC and then they want to convert over to a corporation, so that entails a little bit of extra work. But you can generally count on about $1,200 to $1,500 for the average startup. Most attorneys' fees will do that on a flat fee basis because the work is anticipated, so we know kind of what it's going to cost us already to prepare all of the documents that I've been discussing. Once you incorporate, once you have your minute book, once you have your Secretary of State filing and your registrations with a business oversight department, now you're ready to go. And the next step is going to be for you to maintain your corporate structure. The base requirements for a corporation are to have an annual meeting of the board of directors and the shareholders, which needs to be documented, meaning in writing. And you also need to submit to the Secretary of State a statement of information every year to update them on who the officers and directors are. And of course, you need to comply with the payment of the fees, which are around $800 for an initial small corporation to the Franchise Tax Board for the pleasure of doing business as a corporation in California. So we touched briefly on liability protection as a reason for incorporating. And it's really important for you to remember that the corporation will only give you the benefits that you seek from it when you treat it as a separate entity. That means that you can't commingle personal funds with corporate funds. You can't treat a corporation like you would a sole proprietorship. You have to generally respect it and its limitations. So if you are going to be getting any money from it, you should consider talking with your CPA about the appropriate salary if you're going to be an officer, and then determining what the appropriate distributions or dividends are beyond that. Because what you don't want is you don't want to put yourself at risk for being audited by the IRS and having the IRS determine what your appropriate salary should be as an owner, and then having to pay that back plus fines and fees. So it's really important to work with a CPA. The first couple of years for every corporation, no one expects you to make money. But once you start making money, it's really important to take a look at what the salary, what salaries the officers are receiving, and what the distribution and dividend schedule is for them. So we'll talk just very briefly on the roles of a private corporation, which are a closely held corporation. And I'll just briefly discuss the difference between a publicly held corporation and a closely held corporation. When you start off in your new venture, you will be a closely held corporation generally. You may ultimately gain great success and become a publicly traded entity, but at the outset you will be a closely held corporation. That means that your securities are held by the owners who are actually working the business, and a majority of the owners are also employees of the business. They are not independent investors, they are not members of the public. You have not obtained funding by public solicitation. You may have some private funding, but it's not generally done in the public atmosphere like Walmart or Target or other large publicly traded entities are. So the roles of a closely held corporation in terms of a board of directors are going to be twofold. One is advisory. The board of directors generally consults with the shareholders and management concerning the strategic direction of the company. In a very large corporation, the board of directors is different than the shareholders and is also different from the officers of the company. But in a smaller one, those roles tend to blend. So you're not as expected to have these clear definitions at the outset. But it's important to know what your obligations are as a board member, and it's also important to know what the obligations are to board members who don't have a stake in the company, meaning they are board members who are only acting as board of directors, who may also not have share interest or any other interest in the company, because those individuals may be at higher risk for liability since they don't have a stake in the company. So it's important to know what your obligations are as a board of director. The second is operational. The board of directors provides oversight to the officers, primarily the three ones that I discussed: the president, the treasurer, and the secretary. The main importance in a closely held corporation is that you just make sure that you have someone designated in that title. It can be the same person or it can be three different individuals, but you're going to want to have someone publicly designated as such. Sometimes people use terms like CEO instead of president, which is fine. Sometimes people use terms like CFO instead of treasurer, which is also fine. So it doesn't necessarily matter the titling as long as it's something that's clear that they are acting in their capacity as president, treasurer, or secretary, etc. There is a chart that we will show that discusses the different layouts of a corporation. It talks about the structure, so you can see that. The duties of a board of directors are many, and they can be very intimate if they are a closely held corporation where the directors are also the officers and are also the owners. So their roles are going to intertwine, and if there's not going to be as much clear definition in the role of directors. But generally, directors are there to supervise, or not supervise, but oversee the officers, and they're there to answer to the shareholders as well. The main duties of a board of director are going to be the duty of care, meaning that the directors must make decisions with due deliberation. For example, it's what's similar to what's owed with partners. A director can't make a decision that is in self-interest, meaning that it's self-serving to that director, simply because the director is going to gain some personal benefit from it. The director has the obligation to the entire company to make a decision that's best for the company. The duty of loyalty is also an obligation. And this is kind of a key one, especially when you're starting up and you have different members of a team. They may not be very familiar with each other. They may not have a long history of working together. It's important to set with clarity what the obligations of each of the officers are and what the duties are, because you don't want a situation where you have a company that is creating, for example, a widget, and the company is getting money and is spending money to put that widget out on the market. And you also then maybe have a board of director who's decided that they could probably sell this widget on the side independently and make some money that way as well. That would be a violation of both the duty of care and the duty of loyalty of that director, and could raise problems with the board governors, that director specifically, and for the corporation as a whole. So it's important to have an understanding of what your obligations are going to be as a board member. You can have errors and omissions insurance as a board, so that's something that you can look into. That will help protect the common negligence or any actions by the board that could be generally subject to coverage under those policies. And it provides a little bit more of a comfort for anyone who may be asked to sit on the board, especially if this is an entity that might go public or is getting big, that they are rest assured that they have some insurance coverage for acting on that board. It's also important that there's certain things that you be aware of that you're not going to be able to get away from, even if you're acting as a board member, especially in a small company. For example, payroll taxes. If the company or an HR department is wrongfully collecting, attributing, or paying payroll taxes for their employees, the officer and ultimately potentially the board of directors could be personally responsible for that. The reason why is the state of California has specific law regarding wages and the appropriation and misappropriation of employee monies for that purposes. So the corporation is sometimes not going to be a shield for that. So it's important to know where your exposures are as an owner of a company. It's also important to keep in mind as you start your company to try to have conversations with your fellow owners about each of your responsibilities. I strongly advise and recommend that every client that I have that is a corporate entity has a buy-sell agreement between the owners. The reason for that is, more often than not, the disputes will happen at some point in time between partners. And it's always best to have an agreement in writing that lays out what happens in several situations. In the event of a dispute, in the event of the death of a shareholder or owner, the disability of a shareholder or owner, the retirement, or the simple act of owners wanting to part ways amicably. It's always best to have those agreements and a plan in writing before that event happens in order to avoid the disruption of operations to the company, and also ultimately potentially the demise of that company because of structural issues within the ownership. So a buy-sell agreement is a vital document that you should have if you're going to have more than one owner. So what are the next steps for you? The next steps for you are going to be to figure out what your role is going to be in the company. Who are you? Are you going to be an owner? Are you going to be an employee? Are you going to be a consultant? Those are important determinations to make so that you know what your obligations are, what your responsibilities are, what your investment looks like, and how you will be ultimately compensated for what you do for this company. Also, you're going to want to meet with a certified public accountant. You're going to want to know what your obligations are as a startup and as an ongoing company to pay the Internal Revenue Service, so the IRS, and the Franchise Tax Board. When your tax obligations are due, how you're going to do your taxes, whether you're going to make your S election or not make your S election. You're going to want to also meet with an attorney and find out what the next step is for formalizing your entity. Do you want to formalize? Do you not want to formalize? What are the advantages? You also, if you decide to formalize, you're going to want to think of who you're going to be owners with, or who's going to be on your board of directors, and what that's going to look like. You may want to hire officers, which could be you or your fellow owners, or maybe an independent third person if you have the funding for that. You'll want to keep your corporation current. You want to pay your taxes. You want to keep your registrations with the state active. You're going to want to maintain your corporate book, your annual minutes, minutes of any important meetings, board resolutions. A lot of banks, a lot of lenders require board resolutions before they will lend money, before they will issue credit lines. So it's important to know what those look like and to keep them in your minute book or in some place that is accessible to the secretary, the treasurer, the president of the corporation. That's pretty much it for today. If you have any questions, I believe my information will be posted somewhere on this video. You're free to send me an email or give me a call. I wish all of you lots of luck, and I know that you will be very successful. Thank you.